Excuse me?
Sorry.
No, ain't no excuse me. Don't use that language in my courtroom.
I'm struggling a little bit today.
He's struggling a lot. Mr. Jackson. State of Michigan versus Gary Jackson, 24-03478. Is your phone off?
Yes.
And weren't you instructed to turn it off before?
Yes.
And so you didn't do it, and then it rings again, and then you blurt out disgusting language in my courtroom?
Sorry.
Yeah, well, it's a fine of $100.
Yeah, for sure.
Yes. Okay, I do have a plea sheet for both the remaining files since defendants plead guilty to count 1 of attempt resisting obstructing in file number 24-03478 and plead to the PA 53 violation in 24-02765. That's completely accurate.
Yes, sir.
Yes, sir.
The remaining was to be dismissed,
It's really an amended count.
amended after
Your
this.
Honor, yes. What goes away is the half for the offense notice because it's a misdemeanor.
That's how you want to proceed, Mr. Jackson?
Yes, sir.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
It's true.
No, that's not what I asked you. I said, did you solemnly swear? Raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give is the truth and the whole truth
Yes.
under
Yeah.
penalty of perjury? Okay,
Yes.
thank you. As to the amended count in file number 24-03478, attempted resist and obstruct an officer, how do you plead?
Guilty.
Let me recognize that has a penalty of 1 year and or $1,000 in fines.
Yes, sir.
And are you pleading guilty to that because you believe you're guilty?
Yes.
As to bond violation, alleging that you, on or about November 23rd, 2024, at 00 hours, did allegedly use alcohol in violation of your bond and violated your bond conditions by not, or by having or causing a third party to have contact directly or indirectly with a Angela Ralston. How do you plead?
Guilty. Yes, sir.
Okay, factual basis.
Okay. Were you in a vehicle at that time?
Yes, I was.
Okay. And prior to that time or at that time, had you been drinking alcohol?
No. Oh, yes, yes, yes.
Okay. And at that time, were you in fact a passenger in the vehicle that was being driven by Angela Ralston?
Yeah, she was drunk.
Angela Ralston is the protected person in this case, that you were to have no contact with her.
Yes.
Also, on that occasion, did the officers then stop you and ascertain? Now, this next solicitation is for the primary offense, the resisting obstruction. The officers were able to ascertain that you were not supposed to have contact with Ms. Ralston, correct?
Correct.
Okay, and so they asked your name, but you gave them a false name initially, correct?
Correct.
Okay, and they asked you to step out, one of the officers asked you to step out of the car, and you didn't immediately, did you?
No, I did. Nope.
And then when you did step out, one female officer, Sydney Farrager, attempted to handcuff you, correct?
Yes.
And you struggled.
Yes.
To the extent that several other officers who were present on scene then assisted her in making the arrest, is that correct?
Mm-hmm. Yep.
And you believe that that constituted obstructing this officer in her duties?
Yes.
Thank you, Your Honor. I have no further.
People are satisfied with the factual basis.
The court is satisfied with the factual basis on accept your plea and find your plea freely, voluntarily, and intelligently given. Are you okay, sir?
Yes, I'm fine.
Okay, because your body language makes me feel like you might be under the influence or something.
I'm not under the influence. I'm just exhausted. I am tired. That's it.
Your
Yes.
Officer, or Your Honor, excuse me. I have been able, be able to see Mr. Jackson in numerous settings, several times when he was in jail. So he clearly wasn't under the influence. And I'll report that he always is, as you see him today. In fact, when he originally entered the plea, so one of these cases that we're going to have a sentencing on here in a moment, he acted that same way before Your Honor, and you had basically the same inquiries. He is quirky, to say the least, and
It's a
very.
little bit more than quirky, He can barely.
Agitated, just
What are you agitated about?
the whole thing, you know?
You ain't the victim. What are you agitated about? We're all here because of your actions.
Yes, ma'am.
You're the last person in this room that gets to be agitated. Did you have a victim that wanted to make a statement today?
Your Honor, we do have Angela Ralston present. She advised me that she wanted to make a statement on the defendant's behalf at sentencing. That's all I know.
That she does want to make a statement?
She is here and she does want to make a
She
statement.
can do so at this time. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. What did you want to share with the court?
Me and Mr. Jackson have worked together for 20 years. Our relationship has not been the best. I won't let him take full accountability for things. We're here today because I had cheated on him and he reacted in a way he couldn't take it. It was not the first time, it was the second time. I have seen, since this last situation, I have seen Mr. Jackson take accountability and seek and do things that weren't ordered from you. Like he has an anger issue. He went, found a therapist, been seeing the therapist, been going.
How do you know?
My daughter takes them, so she tells me this. Mr. Jackson, I just don't feel like throwing him in jail. That's what it is. He needs help, like rehab, like mentally. Because of what I've done, it has changed him. And I'd rather see him getting help than just thrown in jail.
Because of what you did, because of the cheating?
Yes.
Okay. And this is a situation where you find out you were cheating and he assaulted you. And you believe that because you were unfaithful, that warrants an assault?
No, I don't think it warrants, but due to it being the second one and the heated argument, things just got out of control there.
Okay. Did you put your hands on him
I did to defend myself that, yes.
after he put his hands on you?
Yeah.
Anything else you want to share?
No.
You're free to go. Thank you. You can make allocution.
Okay, I'll be brief. The agitated state that you see, as I said, the agitated state is the only way I've ever seen him. I really can't argue against the jail recommendation. How can I do that with the record? I can't argue that it's not fair. I could argue, well, that maybe not the most effective. If you trimmed it a little bit and left probation time, that would allow some oversight. And you might think the question would be, but we've tried that before. If you look at his record, though, it appears that his prior offenses were not during the time that we had domestic relations court or domestic relations court type provisions. At least I don't believe so. And that would give some oversight. Why is oversight necessary? Because as Ms. Ralston just indicated, they've had a 20-year relationship. Every one of those prior records that required domestics involved Ms. Ralston. So despite what's happened with courts, for whatever reason, this couple stays together. And if he gets a straight jail sentence without any probation, if history, bears itself out, the history will be that once there is no hold over him, he's going to be back with Ms. Ralston. So it might even actually be more effective for Ms. Ralston to ameliorate slightly the jail sentence and have some probation. Ms. Ralston alluded to the fact that he's done something finally. I was given a document today by by Mr. Jackson, of counseling records that verify that he has on, he's had a session on October 7th, again on October 7th, on October 17th, on October 22nd, several sessions, and then again on November the 6th, and finally one on November the 20th, with a variety of counselors or clinicians as are listed here. So he has been doing something. Again, I'm not going to
But he
argue.
hasn't been there since October?
Pardon? Was from November 20th. He actually has another scheduled, according to this form, scheduled appointment on the 18th, which I understand he probably unlikely to make, but he has been making these sessions. That it might actually be more beneficial for Mr. Jackson and certainly for Ms. Ralston if he does some sort of probation that has some intense, batters intervention, anything that the court could think of. Because the difference between, let's say, a 6-month sentence and a 1-year sentence with no probation is that he gets out, and again, history being what it is, he's back with Ms. Ralston. But the court has no holds on him, and he hasn't received, any kind of therapy or counseling or whatever. He's on SSI. I'm not sure. He says it's been since birth, so I suspect that the issues that he has that manifest himself today are ones that he's always had. He's only had 8th grade education. He's got a whole bunch of medical issues. He's still ill from, if the court recalls, he was actually supposed to be here 8 days ago. He's still ill from that. So I'm just going to just throw that out there and leave it to the court's discretion as to what to do with Mr. Jackson. Thank you, Your Honor.
So Mr. Jackson has something he wants to say. Do you have something you want to say?
Yes, Your Honor. I'm also, like I said, I'm exhausted with me and her going back to back. And now that this time that we co-parent, I feel like I need to get back a little medication.
You need to do what?
Because it did mess me up.
You say you feel like you need what?
Get back a little medication. It's like I can't sleep. The way we used to talk to each other, you got to believe it to where that's what I was, So I went to go seek help. And it's working, somebody to talk to instead of keeping it all inside. And I really don't want to go to jail. It's up to you, but I don't want to be the same person I was before I went in. So I ain't got too much to say. So
I don't know what
I won't.
you don't want. There's something else you want to say?
Go ahead.
I don't know what your pre-existing medical and mental health it all entails. I know that when you present before the court, you present as someone who doesn't have a lot of control over themselves. That's how you present. Even as you're standing here, you have to have something in your hand, you're swinging stuff. You can't stand up straight. You're huffing, you're puffing. Your phone rings, you start cursing. I'm not looking for you to apologize. I'm looking for you to acknowledge that you don't seem to have control over yourself and over your body. This is consistent with your criminal history. Your attorney made a comment that I dispute, that every last one of these domestic violence on your record had to do with her. No, you had one from 1996. It's 30 years ago. And so so all of these are false. All of the domestics are false. You got one from 96, one from 2004, one from 2006, one from 2014, one from 2016, and one from 2018. But all of them are an aggravated assault 2016. You even had or been charged with felony aggravated stalking. But all of these, everything is fake. Yet you continue to present yourself in this courtroom as someone who lacks control. You're talking over me right now, which is someone who lacks control over their mouth. Your history here does not demonstrate someone who can do probation. That's what the report says, even from the pre-sentence report. You've been revoked or discharged or terminated from probation multiple times because you failed to comply. Even as this matter was pending, you were on bond. And we had to take a guilty plea today to a bond violation because of your failure to comply with the court orders, which is not just not to have alcohol, but not to have contact directly or indirectly with the protected party in this. I don't believe that the statement that was made that what's best for Ms. Ralston is for you to get some programming. No, what's best for Ms. Ralston is for her to leave you alone. If there's a 20-year documented history of violence between the two of you, then you all should not be together. And then your history extends beyond that, sir. You're not a candidate for probation. I'm not going to spend a 2025 going behind you trying to figure out why you can't comply. I'm not going to do that. It's not meaningful. What else are you doing with your life, with your days besides being at home?
Mr. Mom,
You said what?
I'm Mr. Mom, got all kids.
You have custody, you take care of the kids during the day? How many kids are there? What's their age?
14, 13, 20, and 21 now, and 2 grandkids.
Well, a 21-year-old's not a kid then, are they? They're an adult.
They're waiting for their mama to be adults.
So all these
All these
children,
boys too.
all boys live with you. What do you think you're teaching them? About how they should interact with their wives and the mother of their children?
Right.
Your job is to be an example. Your job is not to refer to yourself as Mr. Mom. You're not a mom. You're supposed to be a dad.
Oh, okay. Yes, ma'am.
Excuse me?
Yes, ma'am. I didn't mean it. Yes.
I want to see the report from the. Is this the first time that you?
Yep, first time to call myself to do something for myself. Because I know I need help.
Okay, looks like 2 of these you were in custody.
Yeah, I was getting signed up for one of these.
How frequently are you engaging in the psychotherapy?
Until after I got sentenced today, it's gonna be once a week, but as of now, it's every 2 weeks. And I like her.
Only because you've taken your own initiative to get some psychotherapy. Am I going to give you one chance? And it's the chance is just so slim. I'm taking 0 violations, not a single one.
Yes, ma'am.
Not a single violation will be tolerated, or you will be remanded to serve 180 days in jail. Do you understand that? Okay, so it's up to you, sir. I know you've not been successful in the past, but hopefully at this point, you've taken some ownership over your need to get some assistance as it relates to what's going on with you mentally, and that will help you. That and the fact that you have to provide for children. You need to be there for them physically as their father, and you need to be an example. And that means showing them that you can have self-control even when you're upset. As a practice, it's a practice. You need to start practicing it. Start with keeping your mouth quiet while the judge is talking. That's the first place to start, okay? The other thing you should do is stop swearing in courtrooms.
I think
It's not necessary.
just have it for me, you know?
Well, practice, it's a practice. I'm gonna put you on 12 months probation.
So I'm gonna file for pay on time, pay before the due date.
I'm sorry? I didn't hear your question. Was there a question?
Never mind.
Don't interrupt the judge, please.
Well, it's a practice, so it's an early practice for him. And it's like you have energy that's trying to get out of your body, is what it looks like to me. So if that's the case, it's okay to clasp your hands and twiddle your thumbs, take deep breaths. Yeah, well, now's not a good time to start stretching and rocking because you are in a courtroom. but you need to start practicing releasing the energy in another way, okay?
Before I come in, yeah.
Yeah, well, while you're here too, because you could have a nervous energy while you're standing in a courtroom or any setting, but you don't want to present yourself as someone who doesn't have control. So what you do is you find another way to release the energy so that you still present. You think he doesn't have energy he's releasing? I just saw him take a deep breath. He's releasing energy because you're stressing him out. You are stressing him out right now.
He answers what I call him.
That's what a good attorney does. Okay, 12 months probation. You're going to continue the psychotherapy.
Yes, ma'am.
While on probation, you're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. And you'll provide evidence of that to your probation officer, okay?
Yes, ma'am.
Okay, you can't use alcohol as a coping mechanism at this time. You understand that?
Yes, ma'am.
So if you need to have some further treatment for that, we can get you enrolled in that. You understand? Because I'm not tolerating any violations. It's either going to be a straight and narrow on probation, or you're going to do 180 days in jail, okay?
Yes, ma'am. Yes, you are. Did you take the, can I speak?
You have a question?
Yes, can I go home now?
You're asking me about a no contact order? Is that what you're asking me about?
I don't know what y'all got going on, but I ain't got no telling no more. So can I go home?
Home to where? Does she live there? Oh, I'm continuing a no contact order.
Are you serious?
As serious as a heart attack.
I live on the street. Oh Lord. How are we gonna do that for?
The entirety of probation, or you can just opt for jail.
I was gonna ask
You go to jail, no, listen, you go to jail, I can't put a no contact order. That's your option. But you have a documented history of 20 years of domestic violence interactions with her. It's a no contact order that's going to continue.
So
Ask your question, sir.
never mind.
Not to possess a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You will be required to submit to random preliminary breath testing and urinalysis testing, and you have to pay the fee for that, okay, sir? You can put your keys in your pocket. It's a $30 per month oversight fee that you're responsible for while on probation. So that's $360. Plus a $75 crime victim rights fee plus $50 state minimum cost that you are also required to pay. The probation for the police officer attempted resisting obstructing. You do have the right to request early discharge once you completed half the original term ordered by the court, but you'll still be on probation on the other file, okay? You have a question?
They are the fines on I'm get up here, right?
So pay all the fines and what?
Yeah, man. I'm scared to ask you a question.
Why? I didn't hear you because you're talking too fast. You said pay all the fines and then what?
So if I pay all the fines, I can get off probation faster?
Well, no, what I was explaining to you is that one of these files is a domestic violence file, so you can't get off early. There's no option for early discharge. The other one is you're resisting obstructing. You could request early discharge. It's really not meaningful because you're still going to be on probation, and I'm not ordering duplication of fines on both files.
Appreciate it.
And so you're only paying one oversight fee. You do still have a crime victim rights fee and state minimum cost on both files, but you're not going to be paying oversight on both, and you can't be discharged on the domestic violence because it doesn't require early or doesn't allow early discharge. Okay. Do you have any questions? Okay. I want you to have a seat. We're going to get you down to probation in just a moment.
Thank you, Your Honor.
You're welcome.
Yes, sir.